name is Jordan Walker. I'm with Seaver Walker Paget Law Firm. I'm here to talk about eminent domain law in the state of Georgia, West Warthen project. And with that being said, we're going to go ahead and get started. Again, my name is Jordan Walker. I'm with Seaver Walker Paget Law Firm. We are an eminent domain only law firm, a landowner only eminent domain law firm. Our Georgia office is located in Alpharetta, Georgia. That is our address right there on the screen. Again, we are eminent domain only, landowner only. Attorneys is the only area of practice that we do. We are not with the DOT. We have never worked with the DOT. We've only represented landowners. As a consequence, because it's the only area of law we've practiced, we've accrued quite a bit of information about eminent domain, the state of Georgia, what to do when the DOT wants your land for a project. So today we're going to be talking about the project. We're going to be talking about eminent domain. We're going to be talking about what you're entitled to in the form of just compensation under the law in the state of Georgia. Real quick here, this is a description of the West Warthen Bypass project. As you might imagine, it is involving the widening of SR 15, and it's also creating a new road bypass as part of the project. It's actually two projects in one. You can see a map there to your right, and then you can see a description to your left of the project, what it's doing, what type of land it needs for that project. So in order to build this project, the DOT will need to seize or acquire land from private landowners in order to construct the project. And the DOT, like the state of Georgia, like counties, cities, municipalities, pipelines, power lines, have this eminent domain authority to take land, take private land and put it to a public use. Eminent domain is the forced acquisition of private land for a public purpose. This is something that the government has the ability to do. They have the right to do as a matter of law. And while they can take the property from you ultimately through the courts, you are still entitled to just compensation for that seizure of your property. And what that means is that you're not entitled to what they say you're entitled to. You're not necessarily entitled to what you say you're entitled to. You could be entitled to what ultimately a jury determines your compensation to be. If the matter reaches that point. Ultimately, it's important to remember that because you're entitled to just compensation, you can say no to the DOT's offer when they come in and make it. In the state of Georgia, there are certain procedural requirements that need to be met prior to the DOT filing their eminent domain acquisition, their eminent domain litigation. These are codified laws in the state of Georgia that are required of any entity that seeks to utilize eminent domain for a road project. The first step, the first requirement that landowners become familiar with is the appraisal inspection. And this appraisal inspection requirement basically says that the DOT has to do an appraisal of your property, and when they come out to perform their inspection, they being the appraiser, when they come out to inspect the property, appraise the property, they have to give you the opportunity to be present during that inspection. So doing the inspection and allowing the landowner to be present are two requirements of Georgia law in order to file a condemnation action. The next step, once they've done their appraisal, is to issue an offer. The DOT will come back out. They'll send a right-of-way agent out to issue you an offer that's based on that appraisal. Sometimes negotiations take place after this offer is issued. They don't need to. Sometimes they do. But as part of that offer, the DOT must provide a meaningful summary of the appraisal to the landowner, such that the landowner can evaluate the offer being presented. So assuming an offer has been issued, a deal cannot be struck. Eventually, the DOT will file their condemnation lawsuit. Condemnation is another word for eminent domain. It's the procedure through which eminent domain is exercised. And basically, in this scenario, they file their lawsuit against you. They serve you the landowner with this lawsuit. You'll be served by a process server. And then basically at that point, you have the option to either fight the acquisition and say they can't take it, or say they didn't follow the law, and or you can say that you disagree with the compensation being offered by DOT for your property. If you seek to contest compensation, meaning if you disagree, if you as a landowner disagree with the amount of compensation being offered by the DOT, as set forth in their condemnation lawsuit, which again, you will receive a copy of. If you disagree with that amount, you need to file what is called a notice of appeal within 30 days of the service of the lawsuit, or you no longer get to contest compensation as a landowner. So for example, if the DOT came in and they offered you $50,000 initially, you couldn't reach a deal because you thought you were entitled to 100 or 150,000, and they file their lawsuit and they serve you a copy of the lawsuit, and you don't file a notice of appeal within 30 days of receiving that lawsuit, you get the 50,000. You will not be able to argue or bring forth evidence that you're entitled to more, or 100 or 150, because you did not meet the statutory requirement of 30 days to file that document. So it's imperative that if you do wish to contest compensation at eminent domain, you file the appropriate filings within 30 days of being served the lawsuit. Eventually, if you do that, you are entitled to a jury trial over compensation. Not every eminent domain lawsuit reaches a jury trial, very few do, but you are entitled to a jury trial over just compensation. And next, I want to talk about what you're entitled to from a compensation perspective. I divided this into partial and total acquisitions. As you might imagine, partial acquisitions deal with only acquisitions that acquire a portion of the entirety of the property. Total acquisitions involve taking the entirety of it. So for partial acquisitions, what I tell people to look for, what you're entitled to, for the first thing, the value of the acquisition. What is your property worth? What is your land worth? This is determined by examining sales of comparable properties and coming up with a price per foot, price per acre. And then it's important when you are valuing your property that you value your property on the highest and best use of that property, meaning whatever the use you could reasonably set your property to at the time of the acquisition whatever brings back the most economic benefit to the landowner, that is your highest and best use. So for example, if your property is used residentially, but you believe that it is actually commercial land, if it were to sell, it would be sell as commercial property. If you can make an argument to that effect, you may be able to employ a highest and best use of commercial as opposed to residential. Then remainder damage. Remainder damage is basically what impacts the road will have on the remainder property. And remainder damage comes from any number of impacts, any number of issues, loss of tree buffer, loss of landscaping, anything, and that's for residential. Anything that can increase in noise, increase in debris, et cetera, and so forth from a closer roadway. That's an example of remainder damage. How does the road impact the rest of the property? For commercial properties, usually the remainder damage is limited to, not limited, rather, it's actually much more expansive. Usually, well, these are categories of remainder damage, or at least aspects of remainder damage. Common causes: loss of access, reduced parking, loss of signage, reduced visibility. These are all things where you can get paid for. You can get paid for these impacts that might happen on your commercial property. Basically, how much is your property lost value because of the acquisition? And for business losses, you are allowed to recover business losses if you can prove it, of course, in the state of Georgia. In order to recover business losses, your business needs to be completely destroyed because of the project. And not only that, the business can't be relocated elsewhere. For total acquisitions, the first two components are the same. What's the value of the property? What are the business losses that incurred? There are no remainder damage because there's no remainder. But the third aspect that you're entitled to is our relocation benefits. Relocation benefits is compensation over and above the other items that I've listed. that you're entitled to if a house or a business is being relocated. For residential relocation benefits, you're entitled to moving expenses, and you're entitled to a differential payment. Differential payment is the difference in value between your home and available homes on the market. For commercial relocation benefits, you do not get a differential payment. You get moving expenses and reestablishment expenses, no differential. As far as hiring an attorney, hiring an eminent domain attorney, typically eminent domain attorneys work on two different types of arrangements: contingency fee arrangements and hourly billable rates. In a contingency fee agreement, the attorney's fee is contingent on how well the attorney does for you. Or in other words, how much more they recover than what is offered by the DOT. The attorney collects a portion of that amount. In a hourly billable arrangement, it's a more traditional attorney billable method arrangement where the attorney bills for the work they've done, usually against a retainer, some amount of money that you deposit in order to get their services. They bill against that retainer until the retainer expires, and then it needs replenishing, and then you either replenish the retainer or the attorney just continues to bill and send you invoices. That is the end of my presentation. That is my contact information. If you have any questions about eminent domain, don't hesitate to contact me, shoot me an email, shoot me a call. Happy to talk to you if you have any questions. Thanks for stopping by.